So if you know somebody who has a DUI or has had one in the past, there are really only two main defenses to a DUI charge. So I'm going to share with you those two defenses, but if you stick around to the end, I am going to share with you a bonus way that you can fight a DUI charge, one that attorneys use all the time that could actually get your case dismissed. So stick around. I am criminal defense attorney Hannah Akintoye, and when it comes to DUI charges, I always, mention this in the beginning that it's really, really important for you to avoid DUIs altogether. So get an Uber, get a Lyft if you have to, but there are just so many resources that are available to you in this day and age. I know that when I was growing up, there was no Uber and Lyft. In fact, I didn't have a cell phone growing up. You would have to call somebody on a payphone, and some of you may not even know what that is either. But so many resources that are available to you, no excuse to drink and drive. Nonetheless, if you get a DUI, there are still ways that you can fight the DUI charge so that it doesn't follow you forever. So the first way that you can fight a DUI charge is by showing that you weren't driving or that there is a lack of evidence that you were driving. Now, this typically comes into play in situations where there's a car accident. And if there's a car accident, by the time the police actually arrive on scene, everybody's usually out of the car for the most part. And if there are multiple people that were in the car and everybody is standing outside of the car, the police actually don't know who was driving the vehicle. Now, the way that they get you to admit that you were driving the vehicle is by asking for the license and the registration of the driver of the vehicle. Now, most people are going to be like, oh my goodness, I have all my documents together. Everything is legit. Here's my license. Here's my registration. I was the one that was driving. And that's exactly how you admit to that element of driving under the influence. You first admit that you were driving. But if the police don't know or they're not certain as to who is actually driving the vehicle, then when it comes time for trial, there's a big issue that the prosecutor is going to have to prove, who was driving. Now, let me just mention that if you are the only driver of the vehicle and you get into a car accident and the police arrive, if the vehicle is registered to you and you are standing right there outside of the vehicle, it's very likely that the police are going to infer that you are the one who is actually driving the vehicle. There's no reason for you to stick around, obviously, if it's not your vehicle. And so they would likely infer that you were driving it, especially if the vehicle is registered to you. So just keep that in mind. Now, the second way that you can fight a DUI charge is if there is a lack of evidence to show that you were even drinking in the first place. Now, this, of course, means that you did not provide the officer with any statements regarding whether or not you were drinking. So that's really important. Obviously, your statements are going to be able to be used against you. So if you say I was at the bar or I was drinking, that is additional information that you are providing the police with probable cause to arrest you. So keep that in mind. Now, if there isn't sufficient evidence to show that you were drinking, then again, at trial, there is going to be an argument where there's going to be an issue for the prosecutor to prove that this is a drinking and driving offense, right? There's nothing wrong with drinking. You just can't drive after you've been drinking. So if all they have is evidence that you were either just driving or just drinking, then again, there is a big problem here. Now, when it comes to evidence to show that you were drinking, typically what you'll see in the police reports is something along the lines of there was a strong odor of alcohol emanating from the vehicle, or the driver had slurred speech. Right? All of these things are common standard language that is placed in these police reports. What if you can't even do field sobriety tests because you have medical issues and other physical issues that would prevent you from doing the type of field sobriety test that the officer would request of you? And that's a huge problem for a DUI trial, at least for the prosecutors, because that's all they have to show that you've been drinking, especially if you don't make any statements. So one, it's really important that you don't make any statements. And two, if there's any information that you have that shows or that may be able to help establish that you were not drinking, that is always going to be helpful at trial. So the third, and here is the bonus, right? This is the way that lawyers are able to get DUI charges easily dismissed, is by arguing that the police never had probable cause to stop you in the first place. Why is that important? Well, for one, if the police, stop you and pull you over, let's say that they claim that you ran a red light, right? And as a result of you running that red light, they pulled you over. They found out that you had, glassy bloodshot eyes, that you were unsteady on your feet, that you had slurred speech, and that you were driving. They would typically say that that's enough evidence to be able to charge you with a DUI. If, let's say your breath also smells like alcohol, right? But what if they never had probable cause to stop you in the first place? Then all the evidence that they have now obtained as a result of that illegal stop essentially can get wiped away and not be admissible at a trial in your case. Now, let's say you're a person who carries a camera in your car and your camera is able to record everywhere that you go. Now, in your situation, if your camera actually shows that you were crossing the intersection at a yellow light and not a red light, then the reason why the police officers had probable cause to stop you, i.e. running the red light, essentially it goes out the door, right? And now it's questionable whether the police had probable cause. So if a judge determines that they stopped you illegally, meaning that they violated your Fourth Amendment rights from unreasonable searches and seizures, and this includes traffic stops, right? If the courts say that they violated your constitutional rights by stopping you, meaning that they did not have probable cause to stop you in the first place, then all the evidence that came from that illegal stop, your attorney can request that that evidence be essentially not admissible at trial. So that means any slurred speech that they say that they observed, any glassy bloodshot eyes that they say that they observed, your breath test back at the police station, all a result of the illegal stop. Anything that they observed or say that they're using as evidence in the trial in your case are things that your attorney can argue should not be admissible at trial. So let me give you an example of this. I actually had a client who had a DUI charge, and it was his first offense, very first DUI charge. And I was able to actually get him a diversion agreement where all he had to do was, do some classes, and essentially the case would go away. He did not want to take the diversion because he had a very serious job, that if he were to take that diversion offer, he would essentially lose his job. And so for him, it was all or nothing. He wanted to go to trial. Otherwise, it would make no sense to have a DUI dismissal if he was going to lose his job anyway. So guess what? We went to trial, and my argument at trial was that the police did not have probable cause to stop him, and therefore, by stopping him and continuing that stop, they violated his constitutional rights. Well, guess what? The judge actually agreed with me. The judge said that the police in this particular situation didn't have probable cause due to the reasons that they said that they stopped him. And therefore, the evidence that was supposed to be used at the trial in the case, the prosecutor could not use it anymore. Just because the evidence cannot be used doesn't mean that the prosecutor cannot move forward with the case. But most of the time, if all the evidence that they have is a result of the illegal stop in the first place, then the prosecutor doesn't have any evidence to prove or to present at trial, and they are essentially going to be forced to dismiss the case. So in this situation, what ended up happening at the trial in this case is that the prosecutor had to take a recess to figure out if they in fact did have evidence that they could use to move forward to trial. Unfortunately, they just didn't have sufficient evidence, and therefore they had to go ahead and dismiss the case. So that is the bonus. That is the secret way to getting your DUI charges dismissed. And here's the thing. Even if you argue that the police violated your rights and didn't have probable cause to stop you or pull you over in the first place, if you lose on that argument, you can still use the two main arguments that exist for fighting DUI charges anyway. So the argument that you either there's not enough evidence that you were drinking, or the argument that there is not enough evidence that you were driving. And so just because you invoke that argument doesn't mean that you miss out on the other defenses that you have for a DUI charge. So I hope that information is helpful to you. If you have follow-up questions, always feel free to comment that below, and I'd be happy to answer your questions or even make a follow-up video on any questions that you have. You can reach me as well on my website, mydclaw.com, and ask me any questions that you have there as well. As always, stay safe, and I will talk to you all soon. Take care.